The first court appearance is what, an arraignment or a pretrial?
The first court appearance is typically an arraignment. We often, for many courts, in many cases, we can file paperwork to what's called waive that hearing, so that neither we nor the client needs to appear for that. But an arraignment does need to take place at some point, and that's where the charges are read to the person and they either tender a plea of guilty or not guilty. And then the next court hearing after that would be called a pretrial.
And what normally happens at the pretrial?
There's really 4 different options or 4 different choices. Either choice or all 4 choices will result in another court date being set. So typically for us, when we're handling the case, just because of all the time constraints that are applicable with the court and the amount of time that it takes for us to do our investigation and collect the information, by the time that first pretrial comes around, we're not done with our investigation. And if we can't call up the court and have them agree by phone to reschedule it to another date, we appear and ask the judge in person to reschedule it for another date. So that's the first choice.
Are they usually pretty lenient about adjournments?
Most courts are, particularly for the first one, because the courts understand that there's some difficulty just because of the way the system works with collecting the information in a timely way. If we're done with our investigation, then the next 2 choices would be either to advise the court and the prosecutor that we have an issue, a legal issue that we want to bring before the court so that the court can decide or make a ruling on it, or we want to negotiate a plea bargain with the prosecutor. We may talk to the prosecutor and see if we can resolve the case through plea bargaining in a way that's satisfactory with our client. If there is a plea bargain, then we would be coming back on another day for sentencing. If there is a legal issue that we need to have the court resolve, then we would leave the court with a date for hearing on that legal issue. And the 4th option would be simply to schedule the case for trial. So those are the 4 options.